Today we're focused on special circumstances and not-for-profit healthcare facilities. My name is Gina Bokra. I am the department's Chief Sustainability Officer, and we're glad to have you with us today. Our seminar today will cover the technical requirements of an application to the department for an adjustment, and we will start off with a brief background of Local Law 97 of 2019. We're going to focus on special circumstances that might affect a building's annual greenhouse gas emissions, how you identify and calculate your excess emissions, and how you address those in a greenhouse gas emissions reduction plan. We also will point you to resources at the department for both of these adjustments and show you where to find those. So at the end of today's presentation, you'll understand the code requirements to qualify for an adjustment, both for buildings that have excess emission and for those that have a not-for-profit healthcare facility as an occupant. We'll look at the calculation methodology briefly and talk about how you determine greenhouse gas emissions intensity for your building. We'll talk about what qualifies as a special circumstance and some of the necessary components for an application for an adjustment. So we're going to begin today with an overview of the law. And for that, we're going to step back and look at the Climate Mobilization Act. The Climate Mobilization Act was passed in April of 2019, and it included several laws. Local laws 92 and 94 require that all new roofs in the city will be covered either by solar panels or by a green roof, with some exceptions. This law promotes on-site renewable energy and also reduces greenhouse gas emissions that result from treating excess stormwater after rain events. And so these two laws can also help your compliance with Local Law 97. Local Law 95 assigns covered buildings an energy grade that is based on the energy benchmarking score. Energy benchmarking can tell you how your building's performing in comparison to others and give you some input on how you might expect to comply with Local Law 97. Local Law 96 authorized PACE financing, that stands for Property Assessed Clean Energy. That provides access to long-term, low-interest loans for owners to make those upgrades necessary to comply with Local Law 97. And that loan is actually tied to the building, not the owner. And then there's Local Law 97, the cornerstone of the Climate Mobilization Act. And that law limits greenhouse gas emissions from buildings. It's also helpful to step back and recognize some of the laws that preceded the Climate Mobilization Act. The Greener Greater Buildings Plan was passed in 2009 and required energy benchmarking, energy audits and retrocommissioning, and upgrades to lighting and sub-metering of certain spaces. So most owners that are subject to Local Law 97 have been subject to these laws for a few years. Your energy benchmarking will help you understand your future compliance with Local Law 97, and it may help you understand when you need to do upgrades to reduce your energy consumption. If you've submitted an energy efficiency report for Local Law 87, that serves as a foundation for your Local Law 97 planning. And if you haven't yet complied with the requirements of Local Law 88, which has a deadline of January 1st of 2025, then compliance with that law is going to help you with your compliance with Local Law 97. So these laws are all very intertwined. Now let's focus on Local Law 97, and we'll review some basics before we get to the topic of adjustments. Local Law 97 requires that we reduce emissions from buildings, from the building sector collectively, 40% by 2030 and 80% by 2050. Within the law, there are requirements for city buildings. Those are the buildings that are owned by the city, or for which the city pays all of the energy bills. And those buildings must meet even more aggressive targets. So they have to achieve a 40% greenhouse gas reduction by 2025 and a 50% reduction by 2030. NYCHA buildings are not subject to the reporting requirements of Local Law 97, but they still have to meet the same targets as other private sector buildings. So again, 40% by 2030, 80% by 2050. It's a common misunderstanding that NYCHA buildings and DCAS buildings are exempt, and they are not. So a place to get started is to look at the definition of covered buildings in the law. And if you start with section 320 of the Administrative Code in chapter 3, the term covered buildings is the key to understanding how your building must comply. Covered buildings are generally any building that is over 25,000 square feet. But it also can include 2 or more buildings on a same tax lot that together exceed 50,000 square feet. So it is the case that some buildings subject to Local Law 97 could be less than 25,000 square feet themselves. And likewise, buildings that are condominiums under the same ownership and exceeding 50,000 gross square feet are also included. Now let's talk about what is not included. These are the exceptions from the code. So some of them are exemptions, but most of them are not. Industrial properties used for electricity and steam generation are not covered. Low-rise residential with common systems serving not more than 25,000 gross square feet are covered under section 321. City buildings and NYCHA buildings, again, are subject to greenhouse gas emission limits, but do not report under the same structure under 320 as other buildings. Rent-regulated accommodations are buildings that have over 35% of their dwelling units as rent-regulated units, and those buildings are subject to Article 321. Religious houses of worship where the building is classified as assembly and A3 use are subject to Article 321 on a case-by-case basis. Article 11 Housing Development Fund properties and federal housing projects may be subject to 321, or they may be exempt. So let's understand where our emissions come from. This breakdown shows that while 1 to 4 family homes are about 82% of our building stock by count in the city, that becomes a very different story when you look at area or at GHG emissions. So as you can see, they're 82% of our total building count out of the 1.1 million buildings we have in New York City. But other uses such as multifamily, commercial, industrial, and institutional actually make up the larger portion of area in the building stock in New York City and are responsible for a much even higher percentage of our greenhouse gas emissions. So it's important to note that while they are a small percentage of our building count, large commercial buildings and large multifamily buildings make up a large percentage of the greenhouse gas emissions for the building sector. That's why this law focuses on large buildings. It's also important to note that there are a handful of open items in the law that are still being worked out. And we know this adds some uncertainty, but it is important that industry experts lend their advice and their recommendations to some of these complicated details. So the law requires an advisory board process, which launched in December of 2019. There are 19 members of the board. Half of the members are representatives selected by the mayor's office, and the other half are representatives from city council and the speaker's office. The working groups and advisory board have now held over 100 meetings to date. So this work is ongoing and will culminate in a report back to council and the mayor's office in January of 2023. So you can see here that there have been 8 working groups identified by the advisory board. 6 of these 8 are active, and the process is bringing together some great minds to work on making this law successful. These working groups include representatives that are from the commercial and multifamily sectors, experts looking at carbon accounting, others who are looking at how our energy grid is going to change over time, a group that is focused on the economic impact of this law on the city, and others who are giving us advice on communications and implementation of the law. And the working groups and advisory board recommendations, again, are due to council and the mayor by January of 2023. However, some of these issues may actually be addressed by the process sooner. Where do the emission limits come from? These are established in the code, and there are multiple compliance periods associated with these limits, which will progressively lower over time. So there are values set for 2024 to 2029 and values set for 2030 to 2034. The limits are different for various occupancies in a building, and to that end, your reporting should reflect what's actually happening in your building. And it should align generally with the building certificate of occupancy. Later years or later compliance periods will have those values set by the advisory board, the Department of Buildings, and the Mayor's Office of Climate and Sustainability as we get through our advisory board process. There are other factors that affect compliance. The law allows certain deductions for renewable energy certificates, greenhouse gas emission offsets, and clean distributed energy resources. Some of the details on accounting for these types of deductions are still being debated by the working groups. So in the future, reporting for Local Law 97 will have to be submitted by the registered design professional, meaning a registered architect or a professional licensed engineer in the state of New York. What happens if you don't comply? There are very steep penalties for non-compliance, up to $268 per metric ton of carbon that you exceed over your limit. And in addition to the penalties, if you fail to report or are found to have filed a false report, there are other penalties, a civil penalty of 50 cents per square foot per month for non-compliance and failure to report. And there's also a fine of up to $500,000 or risking prison of up to 30 days for filing a false report. So we hope everyone takes this very seriously. All right, so we've talked about the definitions of covered buildings, which are very similar in Section 321 than those in Section 320. Again, there are different requirements under 321 that are specific to these different buildings that are accepted in Article 320. But again, we're still looking at buildings generally over 25,000 square feet, one or more buildings on the same tax lot that together exceed 50,000 gross square feet. Again, meaning a smaller building might be captured in the Local Law 97 universe, or again, buildings in condominium form of ownership that are over 50,000 gross square feet. So let's look at how the law differs for Article 321, which is not subject for an adjustment. Under Article 321, there are two pathways for buildings to comply. They must implement certain prescriptive energy conservation measures at their building prior to January 1st, 2025, or if the building performs well enough, they can demonstrate in 2025 that they've already met the emissions limits for 2030. And that is a one-time report. But in order to comply, an owner must implement all of these features that are applicable to their building. So as you can see through this list, some of them are not insignificant. This is only a portion of them. You can read these here. I'm not going to read all of them to you. And this is the remainder of the list, which can be found again in Section 321 of Chapter 3 of the Administrative Code. So if you are looking at your compliance planning for Local Law 97 and you're not quite sure where to start, this list of prescriptive measures in Section 321 of Chapter 3 of the Administrative Code is a great place for you to start. All right, now let's look at the adjustments program requirements. And just again, to be clear, note that the adjustments are for buildings that are subject to Article 320, those that must report their actual greenhouse gas emissions to the department on an annual basis beginning in 2025. This adjustment does not provide assistance for buildings that are regulated under Article 321, which we just discussed. So you've learned that the law is intended to achieve a 40% reduction in greenhouse gas emissions by 2030. And these applications to the department for their emission limits must be submitted by a registered design professional, just like Local Law 97 reporting. And they are due to the department at different deadlines that are coming up soon. So for excess emissions due to a special circumstance, the deadline is June 30th, and for not-for-profit healthcare facilities or hospital facilities, this adjustment application is due on July 21st. The adjustments we're focused on are, again, very specific. And so if you take a look at this section in the code, you'll note that there's another adjustment available to owners under Section 320.7, an adjustment to applicable annual building emission limits. The requirements for that application are still in development, and it does not have a deadline coming up anytime soon. So just to be clear, the adjustments that are in this current program are for Sections 320.8, and Section 320.9, not including 320.7. What is the purpose of this adjustment? These adjustments do not exempt a building. It only temporarily increases the emissions limits for the building, and it gives the owner more time to come into compliance with the law. Both adjustments allow a building to establish a new limit based on their calendar year 2018 emissions. So that means we're basing their adjustment on the energy that they used in calendar year 2018, and they reported to the department in 2019 in their benchmarking report. For 320.8, the adjustment will help buildings that have special circumstances that present challenges for the owner, but the owner still has to show that their building is an otherwise energy efficient building already. And the requirements for 320.8 are very important. First, you can only qualify for this adjustment if your emissions are more than 40% above your 2024 limits. If they are, the excess emissions must be due to a special circumstance in the building. And you can see the language from the code here. So what is a special circumstance? The law includes a few examples, but the adjustment is not limited to those examples. So these include 24-hour operations, operations critical to human health and safety, high density occupancy, and a few others. The important criteria is that the energy usage in the building is not typical of a building of a similar occupancy. So here's an example. Perhaps you have a 24-hour pharmacy in the first floor of a residential multifamily building, and that's not typical of a multifamily building. Even if you might find a retail space in a different residential building, most of them are not 24 hours a day operations. So that example is an example of a special circumstance, but what about an example that wouldn't qualify? Well, the law calls out 24-hour operations, and multifamily buildings operate 24 hours a day. But nearly every multifamily building operates 24 hours a day, so the residential portion of that building is not included as a special circumstance. The department has not defined an exhaustive list of special circumstances, just as the law does not. So we have left it open to interpretation, and you can reach out to us if you have a condition that you think might qualify. Another requirement is that the owner must be able to demonstrate that they already have an energy efficient building. So it must be one that has energy performance in line with a building that was designed under the 2024 New York City Energy Conservation Code. And this can initially be demonstrated first on your GHG emissions. So if you look at your emissions and they comply without your special circumstance with the 2024 limits, pretty good chances that your building is also going to perform like a 2024 building. So we'll talk about that in more detail soon. If the building emissions are really the building systems are really complex, you might actually need to have an energy model to help us understand it. And finally, in order to get an adjustment under Section 320.8, you have to have a greenhouse gas reduction plan so that you're going to comply with the emissions in 2030 by that time. So these requirements that are in the law are very high bars. It's not an insignificant amount of work to demonstrate that the building meets these requirements. And also worth noting, the adjustment can only be granted if your certificate of occupancy is unchanged after 2018. So if you meet the requirements for an adjusted limit, the new limit of the building, again, in 2024, will be 70% of your calendar year 2018 emissions. An extension may be possible in 2030 under the law, but we have not yet determined what those requirements will be that will need to be met for an extension. Keep in mind, this adjustment may not eliminate an owner's total risk or penalty. Let's now look at the adjustment for not-for-profit hospital and healthcare facilities. This adjustment is available for any property owned by a not-for-profit hospital, not-for-profit health center, or a not-for-profit HIP or health insurance program center. The department will also grant an adjustment to a portion of a building that is leased to a not-for-profit healthcare organization, even if the owner of the building is for-profit, or in the terms of Department of Finance, a commercial owner. Like the adjustments for excess emissions, this adjustment allows an owner to base their limits on the 2018 calendar year emissions. So setting that limit for 2024, it's a 15% reduction over your 2018 emission limits or emissions, and in 2030, it's a 30% reduction over those 2018 emissions. Owners that wish to apply for this adjustment need to submit a copy of their Department of Finance Notice of Property Value. It will reflect whether the entire building is used for the not-for-profit owner, or in some cases may show the department that an owner leases some portion of their building to a for-profit tenant. In those cases where a for-profit tenant is present, that space must be excluded from the adjustment. If an owner that is for-profit is pursuing this adjustment based on their not-for-profit tenant, then that owner must submit a copy of the tenant's IRS determination letter confirming the tenant's status as a 501c3 nonprofit. They must also submit an affidavit that describes the terms of their lease agreement with the tenant. It's worth noting that this adjustment is specific to not-for-profit healthcare organizations. It is not available for other not-for-profit organizations, and it is not available for for-profit healthcare. Now that we've covered the details of these two programs, you can find more information in the resources on our website. We'll point those out as we move along. And we encourage those who are preparing these applications to look at those resources on our website, in particular, the filing guide for the adjustments application. Now I'm going to go into a very quick review of the application process. Applications will be submitted only in DOB Now. It's our electronic filing tool for the department. If you do not have an e-filing account, you may go to the website noted here, nyc.gov/e-filing tips, for the instructions and create your account. Both the owner and the registered design professional who's preparing their application will need access. I'm going to take the opportunity again here to highlight the deadlines for these applications, which are in the law, and that means DOB does not have the authority to change or extend these deadlines. For excess emissions due to a special circumstance, again, that deadline is June 30th. For not-for-profit healthcare organizations, the deadline is July 21st. There's quite a bit of data and information that must be entered into the system in order to apply for this adjustment. It includes the following. At first, you need to help us understand what your composition is in your building based on occupancy and square footage. So that helps us to determine what the emissions limits are for your building so that we can compare them to your actual emissions. Your actual emissions are based on calendar year 2018 energy usage broken out by energy source. So this is what you submit to the department with your local law 84 data. Very few buildings will have the situation of not having reported this data before, but it is possible. So in those cases, you'll be relying on your utility bills to develop that information. Also need to show us that your building is performing equivalent to a building designed and constructed under the 2014 New York City Energy Conservation Code. Again, this is a very high bar, but to start looking at this, check your emissions minus your special circumstance, and that will give you some clue as to whether you're close or not. You also have to have a greenhouse gas reduction plan, which is going to include all of the strategies that you have to implement in order to get to your 2030 limits. We want to see how energy use is breaking down in your building, not only currently, but how that looks in the future after you've implemented your greenhouse gas reduction plan. And then for those that are filing for an adjustment for not-for-profit healthcare, you need to demonstrate your not-for-profit status to the department. There are a couple required documents. The department has developed an Excel workbook, which we call the EN97A workbook. It's on our website, and it'll assist applicants in collecting the information that's necessary to fill out the application in DOB Now. That workbook should also be submitted as backup documentation. Other supporting documentation will include reports on these different pieces that will be uploaded into the system. So let's look at the details. On the equivalency report, we have some tips on how to file for that portion of your application. We've discussed the fact that the building must have energy performance that's equivalent to a building constructed under the 2014 Energy Code. But if your building does not meet that performance now, and you can make alterations to be equivalent prior to 2024, then the department may still be able to approve your application. In addition to the other requirements, you will have to submit a New York City Energy Conservation Code equivalency plan to show how the building will meet that requirement in the future. However, keep in mind, the department can monitor your progress on that plan leading up to 2024 through your benchmarking reporting. And if the systems in your building are very complex, you may need an energy model to demonstrate to us how you are going to comply. If you get to 2024 and you can't show your equivalency with the 2014 New York City Energy Conservation Code, then your adjustment application will be denied. There's also the greenhouse gas reduction plan. You must describe the energy conservation measures or other operational changes that you will make in order to comply with the 2030 emissions limits. It's not enough to promise that you will get there. You have to show us how you will do it. And these two plans are not required for the adjustment for hospitals and healthcare facilities. As I mentioned, we have a filing guide on our website that covers both adjustments. This guide is focused on the users who are preparing the application on behalf of the owner, the architects and engineers. The filing guide walks through step by step on how to apply and includes guidance on how to prepare and submit your documentation. There are not templates for the process and the reports, as these could vary based on the information being submitted. You can find the guide on our DOB website on the greenhouse gas emissions reporting page. You see that address here below at the bottom of your screen. All right, so what do you do to prepare for compliance as you're considering these adjustments? The law is really complex, so we encourage everyone to understand what their emissions look like now, the occupancy breakdown of their building, work with a registered architect or a licensed professional engineer to determine what compliance path is the most appropriate for your building and how you are going to get there. The department's working along with the Mayor's Office of Climate and Sustainability, HPD, and other agencies to produce more materials to assist owners in their compliance planning. Many owners that have buildings subject to Local Law 97, again, have already done an energy audit to comply with Local Law 87 of 2009. If you haven't, now is the time to go through that exercise. Or if you have, it may be a good time for you to update your audit, because many audits in the past look only at short payback period strategies. So some audits don't go to the extent of deeper greenhouse gas emission strategies that you need in order to comply with Local Law 97. An audit can help you inform your compliance strategy and determine what upgrades might be made in your building in order to reduce your greenhouse gas emissions and save energy. And when you're making your plans, be sure to look out into the future at the emissions limits for later compliance periods, not just for 2024. And again, keep in mind, the department's working with the Local Law Advisory Board the Mayor's Office of Climate and Sustainability to develop the details on how these other strategies will play a role in Local Law 97. So in addition to improving your efficiency, you might have the option to pursue renewable energy credits, greenhouse gas offsets, clean distributed energy resources, and carbon trading in the future. However, those components may not be considered part of your plan for your greenhouse gas reduction strategy for an adjustment. First and foremost, you must do what you can to save energy in your building and do what you can to educate your tenants. As you are preparing for a filing, make sure, again, you're working with a registered design professional who is licensed in New York. Conduct that energy audit if you haven't, and work with them to determine what your emission limits are. Again, these are based on the area breakdown in your building by occupancy with coefficients that are established in the law. If your building is complex, just a reminder, you might have to do an energy model to develop your GHG reduction plan or your ECC equivalency plan. And then validate your 2018 energy usage. Again, this may be all informed by your 2018 benchmarking report to the city, but Energy Star doesn't report in the same way as Local Law 97 accounts for energy consumption and greenhouse gas emissions. We're just reminding owners, make sure all of your meters were accurately reported and start looking at what you can do to reduce your emissions. So what questions should you ask yourself as you're preparing for this filing? Are my emissions 40% over the 2024 limit for buildings with excess emissions due to special circumstance? Is there a special circumstance in my building? Are those excess emissions due to my special circumstance? Are they such that my building is equivalent to a 2014 New York City Energy Conservation Code compliant building? Or can I make it compliant and equivalent to such a building? And can I do that before January 2024? Has the certificate of occupancy been amended since December 31st of 2018, or will it be? And then for owners with not-for-profit hospital or healthcare facilities, you want to ask yourself the question, was the building classified as a not-for-profit hospital, healthcare center, or HIP center on November 15th of 2019 when the law went into effect? Has it been since, and will it be in the future? And can I document the not-for-profit status for my facility? Can I also document the terms of my lease if I have a not-for-profit hospital or healthcare organization as a tenant? So again, as you're preparing for filing, make sure that you have your energy use data from 2018. That's your Local Law 84 data. And if you do not have that data, you need to have information on the metering of the building, how energy use is breaking down, and your utility bills and records as supporting documentation. Again, we have references on our website that can help you through this process. Please make sure you check out the Local Law 97 Adjustment Application Filing Guide, the EN 97A workbook, and the instructions that support it. And these can be found on our greenhouse gas emission reporting page. If you still have questions, you can email our team at this address, ghgemissions@buildings.nyc.gov. This presentation will also be available on our website after today's event. If you're looking for these, please, again, go to our website, the Greenhouse Gas Emissions Reporting page, or if you look at this service notice from April 9th, many of the links that you need to access these resources are there. And it's also worth reviewing this section of the law in Chapter 3 of the Administrative Code, sections 320 and 320 and 321.